It's 9:30, so we're going to go ahead and get started. My name is Erin Kopek, and I'm the Marketing Director here at Higher Level. And you have joined our Workforce Excellence webinar entitled The White Collar Exemptions, talking about communication and reclassifying employees. So today we have Jennifer Zanasco of Littler Mendelson, and she will be introduced momentarily. Just a couple things before we get started. This call will last probably close to 30 to 45 minutes. And you will have the opportunity at the end of the presentation to ask questions. So if you do have questions, please feel free towards the end of the webinar to type those in, and we will do our best to get those answered for you. All right, so let's get started. So Jennifer Zanasco has experience in a wide range of labor and employment matters, including litigating discrimination and retaliation claims, wage and hour collective and class actions, and unfair competition cases before federal and state courts. She has conducted fact investigations, drafted position statements, represented witnesses during agency interviews, and represented employers during fact-finding conferences and mediations before administrative agencies such as the Equal Employment Opportunity Commission, the Missouri Commission on Human Rights, and the Illinois Department of Human Rights. Jennifer has handled all stages of the litigation process, including formulating defense strategies, taking and defending depositions, representing employers at mediation, negotiating and drafting settlement agreements. In addition to her litigation practice, Jennifer regularly counsels employers on human resource matters, including hiring decisions, conducting investigations, reviewing employee handbooks and other policy manuals, complying with federal and state employment laws. Jennifer served as a law clerk for the Hon Mary R. Russell of the Supreme Court of Missouri while at the University of Missouri School of Law. She was a managing editor for the Missouri Law Review and a member of the regional mock trial and regional moot court teams. Prior to attending law school, Jennifer was a human resource specialist at a local St. Louis company. She is certified as a professional in human resources. We welcome you, Jennifer, and I turn it over to you.
Good morning, everyone. This is the third in our series of webinars focusing on the overtime regulations. So I hope that there are folks that have been able to join us each month as we talk about these different issues. As Erin said, I'm an attorney with Littler Mendelson. Littler Mendelson is a global labor and employment firm, and all we do is represent employers in different areas of the law that touch the employment relationship. So pretty much everything that deals with the employment relationship we do. With respect to the wage and hour arena, we're very uniquely situated within our market because we are fortunate to have within our ranks a former administrator from the Department of Labor. And she has really been on the forefront of helping us make sure that we are giving the best advice to our clients and other employers about how to comply with the overtime regulations. In fact, she was one of the administrators that was very involved when the DOL did their last set of changes in 2004. So today our topic is about communication, the communication piece. So we've kind of covered a few more basics in earlier presentations, but we did have a few questions prior to the webinar. So I did just kind of want to back up to a few basic questions in terms of the exemption status of employees. So for an employee to be exempt from the overtime requirements of the FLSA, there are three requirements that need to be met. First is that individual is paid on a salaried basis. So meaning you pay them a salary, you pay them a set salary to work however many hours the company needs them to work. The second part is that the individual satisfies the job duties that they're actually performing, satisfy whichever duties test they fall under. There's various duties tests, including ones for the executive exemption and the administrative exemption. So for an individual to be exempt, they also have to make sure that the job duties that they're performing do satisfy the duties test that's required for that particular exemption. And then the final one is where the changes have come and where has been our topic of discussion for the last couple of months, has been that the individual must be paid a certain salary threshold. So that new threshold is $913 per week. Sorry about that. So that's how an individual qualifies for an exemption under the FLSA. So an individual, in order to be exempt from the overtime requirements, has to meet each of those three tests in order for the company to treat them as an exempt employee. Pretty much in terms of the effect of the new rules apply to all employers. There's not a carve out for particular small businesses. If your organization is covered by the FLSA, the new overtime regulations apply to your organization. There is a slight carve out for some providers of Medicaid funded services that is delaying the effective date of the changes, but that's a pretty small piece of employers nationwide. So I want to jump into our focus topic for today, and it's really the communications piece. And as I was thinking about what we would talk about today, I was thinking, wow, this seems like a very simple topic. Just talking about once an organization has made the decision that it's going to reclassify certain employees, that then now what are we going to do in terms of communicating that information not only to management, but most importantly to the affected employees themselves. And although I think it's a simple topic, I think this is probably one of the most important pieces of the process. And it's hard to process that, I think, for many of you that are on the call. You know, if you're in a human resources function or a payroll function, these changes have been something that have been on your radar and on your mind since last year when the DOL first sent out their proposed rule. And you know, there's been a lot of preparation and analysis and work that has gone into figuring out what the organization is actually going to do about affected employees. However, once the decision is made about whether to reclassify them, really the communications part, doing that and doing it well, will reap great rewards for your organization on the whole. You know, in terms of how and when and you communicate that decision. So here's our agenda for the day. First, we're going to talk about why it's important to have a communications plan. And within that, there's lots of different pieces. Who is going to communicate the changes, the substance of the information that will be communicated, how the information will be communicated, and when the communication will occur. So these first few slides are just kind of an overview of, you know, what the requirements are of the new rule. And many of you who've joined us for the last couple of months are well aware of these. The minimum salary level change into $913 per week. There's also a provision that employers can include certain types of non-discretionary bonuses, incentive payments, and commissions to make sure that the individual salary meets the minimum salary threshold. And there's also a change to the level for highly compensated employees up to $134,004 per year, up from the current $100,000 level. And also there's going to be automatic salary level increases. And as everybody knows, the effective date of the new rules is December 1st. As we are wrapping up our summers, it feels like December 1st seems like a far way away, but I think it will be here before we know it. So certainly now is an important time to continue your planning process in terms of the implementation of any changes that you need to comply with the new rules. So I want to move into the substance of our discussion for today. And obviously our substance is going to talk about communicating the reclassification decision. But first I did want to back up a little bit because I think it is important to keep the overview and process, or the overview in mind when you're looking at these individual pieces. So in terms of getting your organization into compliance with what the new overtime regulations will be. First is identifying employees who need to be reclassified, developing the compensation plan for those reclassified employees, and we discussed that last month when we talked about the reclassification process. The third piece is reviewing wage and hour policies and processes. 4 is communicating the changes, and 5 is training the reclassified employees and their managers. And we are going to talk a little bit more next month about reviewing policies and processes and also the training piece. So for this month, we're going to talk about number 4, which is communication. So it's very important to plan for this process because there is, many of you who have been on these webinars have probably heard me say that there are some emotional issues kind of caught up with the idea of an employee being exempt versus non-exempt, or to take it down, hourly versus salaried. You know, a salaried position holds with it, in some people's minds, a level of prestige. You don't have to report your time. You don't have to punch a time clock. You're really more, you're working autonomously, and you know, you're a professional who's doing your job. So for individuals that your organization has that you are going to reclassify from an exempt classification to a non-exempt classification, you really have to kind of think about those issues, and some of them may be kind of thinking about it organizationally and thinking about how that kind of fits in with your organizational culture. But I do believe that there are some employees, even though these changes are mandated by the government, that are still going to view, if they are being reclassified as non-exempt, that they are actually functionally receiving a demotion by moving to an hourly basis and having to report their time to the organization. And I think that the psychological hurdles of that cannot be underestimated at all. I think that it's important for organizations to consider the individuals who need to know about reclassification decisions. Obviously, you know, human resources and payroll professionals have been very involved in the implementation of the changes, but then, you know, how many different people need to know what's going on, and how are we going to get those communications out to the people. And finally, another important piece about planning for this process is your organization wants to have a consistent message about what they're telling employees about them being reclassified and how things are going to work. So it's important to, we recommend preparing written talking points, especially if some of these communications are going to be coming from frontline supervisors who may not be as familiar with the FLSA and its requirements. So to prepare talking points for them to communicate the decisions, but then also maybe have a list of frequently asked questions that will kind of explain things a little bit more generally to the folks that are being reclassified. So after you kind of get past the initial thinking about planning for the process, the first step is to think about who's going to communicate the changes. I think that this is very much an organizational culture type question. Depending on the size of your organization, it may be appropriate for example, if you're a nonprofit organization, you have an executive director along with the board of directors, it may be appropriate for the executive director to be the one communicating the changes, especially if you're an organization of around maybe 25 employees and you have 2 or 3 employees who are affected. The executive director might be the right person to message those communications. You know, in a little bit of a larger corporation or more of a corporate setup, it may be the CEO or the president, and it may be, as I mentioned, also those frontline supervisors communicating the decisions to the affected employees. You also may want to consider doing a tiered approach that, you know, the president communicates to the managers, and then equips the managers with the information that they need to then communicate the decisions to the employees. So it's kind of a step down. You know, each particular level communicates to the next one down as appropriate. And it's possible in your organization it may be better for the communications to come from human resources or a payroll function. I would say, though, generally, if you do try to take that approach, I would somehow try to involve the frontline management, the frontline managers of the particular employees. I think that that's kind of an important piece on just making sure that they're in the loop, but then also that they are they understand what's going on as well. So in terms of the substance of the communication, obviously first step is to tell them why things are changing, and that is because of the government, because of the requirements of the Fair Labor Standards Act. And I would even back this up a little bit, this kind of goes into the couple other points too, to sit down and explain to the employee, you know, currently you are being classified as exempt, which means you're paid a salary and, you know, you don't have to report your time, and you're paid a set salary for the number of hours that you work, regardless of the number of hours you work. And then to transition into saying, you know, the Department of Labor has recently made changes to the regulations, and the significant change that has come about is a change to the minimum salary required for an exemption. And then I think explain that the company has gone through a process to reach these decisions. The company has undertaken a review of all of the positions within the company, and a number of jobs. They made the decision to reclassify a number of the jobs as non-exempt based on the new compliance requirement. And based on that review process, that particular employee's position is going to be reclassified as non-exempt. I would communicate what the timing of the change will be, when that will be transitioned, and we'll talk a little bit about the timing of the communication too, but obviously the communication on the timing and when the change is going to happen is affected by a couple of other things. Let the individual know that as a newly non-exempt employee, what that really means. And what it means is a practical matter. It means that these employees will have to track and record their work hours. And then if they report work hours of over 40 hours per week, they will be paid time and a half. They will receive overtime pay for those times. So the next point goes to what we had talked about the reasons why it was important to plan. Within the substance of the communications too, it's important to let the employee know that this is not a demotion for them. It has nothing to do with their value to the organization, that they do play a key role within the organization and also within their department, and their contribution is definitely valued, and that the changes really are driven by the changes to the law, and it has nothing to do with the employee's individual performance or the company's view of their contribution to the company. If the individual's job duties are going to stay the same, also let them know that your job duties will not change. Some job titles may have been changed for consistency purposes, but for that individual, the employee, their job duties will stay the same. And it's also important to let them know that the company has undertaken a process to ensure that this change doesn't result in a decrease of their total compensation. That really the goal of the company is to continue to make them whole and make sure that even though they're now going to be paid on an hourly basis, that their total salary for the year is still going to be at or above what their previous salary level was. And I would also note that to some extent, if an employee does work over 40 hours, if the hourly rate is just calculated purely on an hourly basis of their salary, then if they work overtime, they're going to actually be receiving more compensation than they were previously given. If there are any changes to the benefits that the employee will receive, those should be communicated. In most instances, benefits to affected reclassified employees will likely stay the same. For those of you who joined us last month when we talked about the reclassification process, there are some organizations that have different benefits available to salaried employees versus hourly employees. And one of the things that an organization can do in terms of making these transitions, if there are certain employees who you want to make sure continue to maintain the benefits that they were eligible for as salaried employees, you could create another category for benefits purposes that would be non-exempt professional employees or something to that extent, that they would still continue to receive the same benefits they've always received. So obviously if the benefits are changing, you know, an employee should be let know, but if they're not going to change, that's you know, that's something that you should assure them that there's no changes on that front. Another big piece of the communication is to really detail out what it is for the employee to be tracking their work hours. Probably the first part of that is really what is considered working hours. If an employee, many salaried employees are used to bringing their laptops home and logging on for an hour or so after the kids go to bed. If a reclassified employee continues to do that and it's okayed by their supervisor and the company, the employee needs to realize that that is working time and that is time that needs to be tracked and reported to the company, and that it's the employee's responsibility to accurately record all of the hours that they spend working. And this is a big shift for a lot of employees because they're not used to recording their time and recording their day. So anticipate a little bit of a rocky transition for some employees, but I think that these conversations are best given to them, you know, at the front end. Also, it should be explained to them that they are going to be given the opportunity to take unpaid meal breaks if that's what your policy reflects, and that employees need to accurately report when they leave and return from their meal breaks. Even if an employee who may have maybe for example if they have an office and they are used to eating lunch at their desk, however, while they eat lunch at their desk, you know, they're looking at their personal email, they're looking at Facebook. If the policy of the company is that these are unpaid meal breaks, the employee then needs to account for that time and actually make sure that they have accurately clocked in and clocked out for those meal breaks. It's important for the employee to realize that off-the-clock work is strictly prohibited, that if there's anything that they do that's work-related, they need to be reporting that time. And make sure that you know, they're not working off the clock. If there's something that an employee has questions about, they should contact their supervisor about you know, what they're doing and why they're doing something that's outside of normal working hours. So the biggest example of that is really, you know, most of us have email on our cell phones. Looking at work email on your cell phones when you're off the clock, that would be prohibited off the clock work. But if the employee is not reporting it, I've defended many lawsuits that have alleged off the clock work, and they are really difficult cases to defend because oftentimes the testimony is just the employee's own testimony that they worked off the clock and they're seeking damages for it. So it's very important for the outset for a company to communicate what the expectation is, and that off-the-clock work is strictly prohibited, because you don't want to have not communicated that up front and then later be subject to you know, a possible class action alleging off-the-clock work, and they'll pay for it. Another piece of talking about tracking your hours is the overtime piece. What the company's policy will be with respect to overtime, if they're going to have a system where if the employee is going to work overtime hours, they need to get prior approval from their supervisor before doing so. Whatever the policy will be on that front, that needs to be communicated with them as well. And the final list that I put was back wages. For most clients, we are not suggesting that when you reclassify someone based on the new salary level, there's no reason to be paying them back wages. And so in the decision, or in the communication, it's important to say, this change is being made because of the new changes to the federal rules, therefore we're not providing you any type of back pay because we think you're properly classified as exempt in the past under federal and state law. It's just now because of the changes to the overtime regulations that you will now be classified as non-exempt. And you also want to make sure that that is true to the case, because there is part of this process, at least what we're recommending to our clients, is that you do look at a lot of your positions and make sure that they're also satisfying the duties tests. And to the extent that they're not, this is really a good time to reclassify them. So the communications to employees who are reclassified, possibly because their position does not fit within the duties test, that may be a slightly different conversation, but I just want people to be aware of, though, that those might need to differ a little bit from what we've discussed. So next is talking about how to communicate the change. If it's going to be an email, a video from the president, CEO, or an executive director, or president of the board of directors, spelling out what the changes are. There's going to be some type of web meeting, almost like a FaceTime or, computer-based system for having one, or whether it will be one-on-one meetings with affected employees. These are decisions that only your organization can make for what's best suited for you. There's no one true and best way to do it. I think it's just knowing your own workforce and knowing your own organizational culture, and then determining what will be best for you and your employees. So in terms of the timing, it's important to consider what the effective date of the transition again is. As I mentioned, no later than December 1st. However, some states require advanced notification of changes in wages. So for some employees, you maybe want to communicate these changes a little bit earlier. I am based in Missouri, so in Missouri, if you're going to reduce someone's wages, you have to give them 30 days notice. Now, if you're making this reclassification and you're going to keep their wages the same, you may not necessarily need to give them that 30-day period, but it's probably better to give them 30 days notice and comply with that requirement rather than having trouble down the line and saying that it wasn't complied with. There also may be other organizational events that you want to plan the timing around. If you have a big sales meeting, or you have regular company or organization-wide meetings, if that's something, that kind of a forum is something you would rather communicate the changes to folks in, those considerations can be made. So that is kind of the substance of what we recommend on the communications piece. Again, for those of you who've joined us in the past, Littler has a really great tool in its exempt toolkit that provides a lot of resources to employers in terms of the reclassification decision and the reclassification process. And one of the things that's relevant to what we've discussed today is the toolkit does come with a communications plan template and materials, which includes specific FAQs and talking points and things like that. So Littler offers this exempt toolkit that includes those resources and many other resources for a flat fee of $4,000, and it also includes 4 hours of consulting and attorney time. So if you have a number of positions that you're considering, it may be a good investment to have access to these resources, as well as access to an expert wage and hour attorney to ask questions specific to your organization. And we have one final webinar in our series next month on September 7th. We're going to be talking about final considerations and implementing the changes, including timekeeping requirements, controlling overtime expenses, and reviewing existing policies. So I thank everyone for joining us today. I do believe we have a little time if anybody wants to pose any questions. Erin will chime in with those.
Yeah, I do not see any questions right now, but if anyone wants to take the next couple of minutes to give us some feedback or provide any questions, we'd be happy to answer those. All right, it looks like everyone's kind of starting to log off, so I'm going to wrap up the presentation. Thank you, everyone, for attending this morning, and hopefully you keep an eye on your email to keep up to date and also attend our webinar coming up in September. And I believe that's it. Everyone have a great rest of your day. Appreciate it. Thank you.
Thank you.